Thank you, Madam Chair and Ranking Member Keller. And thank you to all of our witnesses for their important testimony. Ms. McCutcheon, you had done an excellent job, and thank you for appearing here in person, of describing the onerous implementation and regulations around the FLSA and how difficult it is for a business that wants to comply and is paying a fair wage to comply with those regulations. The FSLA does not define the term joint employer. Congressional Democrats and the Biden administration support creating the broadest definition possible of joint employment and do have concerns about how broad joint employment definition would work with the DeLauro bill, and would it significantly increase liability for employers and threaten the franchise business model?
I think it would kill the franchise business model and also ruin many small businesses. Because they cannot afford the tripling and quadrupling of penalties that this bill would propose, especially in the franchisee business. What company would have franchisees when they're going to be held responsible with these extreme penalties for every minor violation by every single franchisee who is a small business? Better to just have company stores where you can control the pay and the pay practices of the employees in the storefronts with your brand on it. So the broader the anti-joint employment is anti-franchise and anti-small business.
And I know that our small businesses in Iowa are extremely concerned about this, and they're paying, in many cases, well over $15 an hour. Your testimony discusses the complexity of the Fair Labor Standards Act and the value of streamlining requirements. During the Trump administration, DOL issued a final rule on workers' classification as employees and independent contractors under FLSA. This rule emphasized the degree of workers' control over their work and their great entrepreneurial opportunity for profit or loss. Does this rule provide greater certainty for workers and businesses?
Absolutely. Before that, there were no regulations. There was no clear standards at all. It was only informal guidance, which you had to be an expert to find on the Wage and Hour Division website. So these were regulations. They were focusing on who controlled the work, which is the commonality in all, sorry to say this, 100 different federal and state regulations and statutes on independent work. Now, of course, the Biden administration withdrew that rule. A Texas court said that that was illegal, and it is back in force. But here's more confusion. It's not on the Wage and Hour Division's website. They're the Trump regulations that are in force today. What we see on the website is a notice about the law, but not a link to the actual regulations, and they have instead their fact sheet 13, which is a 7-factor test that was in place before the regulations. So to help small businesses and franchisees, they need to put the Trump regulations back on their website and take off fact sheet 13.
So it sounds like that clarifying language needs to be present, and we need to stop practices where we know it's illegal, but we're going to continue to do it. In March of this year, a federal court held that efforts by the Biden Labor Department to withdraw the Trump administration's final rule on independent contractors were invalid, to your point, and that the Trump rule, which became effective in March 2021, remains in effect today. And I think you alluded to this, do you know whether the department is following the Trump administration work classification rule, and will they put it back on their website? Or is that an indication they're not following it?
I don't know. I don't think anybody knows whether they're actually following the law as they're required to do under the Texas District Court. I also don't know whether they're going to appeal that case. So we're in total disarray right now. My advice to employers is the rule is the Trump rule, and that's the rule that you should insist DOL and in litigation be applied.
Thank you so much for your testimony. Ms. Chair, I yield back my